The Supreme Court has agreed to hear Haryana government's plea against a High Court order that struck down a law mandating 75% reservation for locals in the private sector. The state government has argued in the apex court that the High Court's judgment is not a reasoned one. Ashmit Kumar is standing by with more of all of that action from the courts. Ashmit?
Well, just to give some context, in 2020, Haryana had come out with a piece of legislation. What that entailed is that for all private sector jobs where the salary is less than 30,000 per month, in such situations, there have to be a 75% reservation mandate for locals, for local domiciles. That was the bone of contention. The industry bodies in the state, in fact, had challenged it before the Punjab and Haryana High Court. The Punjab and Haryana High Court had held against the Haryana government, striking down this legislation, calling it unconstitutional, calling it void, calling it illegal, essentially ruling the Punjab and Haryana High Court that such a mandate cannot be thrust, especially upon the private sector, that is simply not tenable. It is not in keeping with our constitution. Now, it is that particular High Court order which has now been challenged before the Supreme Court. The Haryana government coming out all guns blazing, essentially batting for its own legislation, batting for that mandate of 75% reservation in the private sector. Importantly, the Supreme Court, number one, has agreed to hear this application, and number two, has issued a notice to the industry bodies that had won in the Punjab and Haryana High Court. Again, hugely significant case this, given the vast scale of the industrial complex that operates out of Haryana. Any such ruling, any such mandates being imposed on the private sector will have far-reaching consequences for the industry players operating in the state.